Good afternoon. I'm starting this presentation with an apology. I'm recording this presentation because for the past number of weeks I've had a bad chest infection, as a result of which I'm currently on steroids and antibiotics, and as you can hear, my voice and chest is a bit wheezy and I have a tendency to break out in coughing every now and again. So rather than coughing to you during a live presentation, the plan is that I'll edit those out of the video recording before it gets to you. I will be available at the end to answer any questions and cough. So the whole point of this webinar session is about client risk assessment and management. And the Scout motto is opposite: be olive, be prepared. That's a shot at me as a 16-year-old Scout in 1976 and later in my 30s as chair of the Federation of Irish Scout Associations, when I had the honour of greeting Carl Gustaf of Sweden, who is chair of the World Scout Foundation. So this webinar is not about AML procedures, it's not about Section 150, it's not about Russian sanctions procedures, KYC, but it is about CYA, and if you don't know what that is, questions and answers at the end. It is about client risk assessment. So I'm going to go through various steps to good risk assessment and management. One is to alert yourself to risks and complaints sooner rather than later. That involves being familiar with what's going on in your office, not just within your own file stock or your own work in progress, but everybody and everything. You need to check credit control. You don't want to be doing an awful lot of work for clients that you're not going to get paid for at the end of the day. You also need to establish a mandatory system of reporting any incident which is capable of giving rise to a claim. If there's what's called a circumstance capable of giving rise to a claim, you're supposed to notify that to your insurer. If you want to claim indemnity, that is, and have an effective insurance policy in place to meet any claim that might arise if it goes beyond a mere complaint. Last week I did a session for the Southern Law Association on professional indemnity insurance, and I'll circulate a copy of the presentation for that as well, along with some other materials. When it comes to complaints, notify your insurer right away about complaints or incidents which amount to a circumstance capable of giving rise to a claim, and be aware when a moan is likely to become a claim or a complaint, or does in fact cross that threshold. Again, next one, number 2, is try and avoid the troublesome clients who will bring you nothing but pain, grief, and ultimately, no matter what you do for them, a complaint, or worse still, a complaint, or a claim rather, from respect to which you'll have to seek indemnity under your insurance policy. If the client looks too good to be true, probably is because they are too good to be true. Make sure you go through proper client inquiries, including ML. Check people out on the web. It's amazing what you can find these days about people, and if their reputation precedes them, it might be one that you don't want. Don't commit to doing huge amounts of work, carrying on a high level of office expenditure, giving credit. Don't incur a huge cost of time or a risk on behalf of a client. Don't be afraid to ask previous solicitors, if the case is coming from previous solicitors, what their position is. Why is the client and the solicitor parting company? The reason for the change of solicitor may be down to the client, but it may be down to the previous solicitor. Third thing is to limit and define the work, the retainer, in other words, the extent of what you're going to do, and the risk. As part of the bonus on this, I'm going to give you a copy of the first 2 chapters of the book written by David Curtin and myself on lawyers' professional negligence and insurance, and it includes the chapters in relation to the whole question of creating the retainer and terminating the retainer and all points in between. You'd be actually surprised. It's very complicated stuff. It would take an entire conference to go through all of what's involved, so I'll give you the benefit of the 2 chapters. Importantly, limit and define in writing the scope of exactly what you're going to do, i.e. the retainer, and what you're prepared to take on behalf of the client, what you're prepared to do for them, but also make it clear what you're not prepared to do. So, for example, no tax work in relation to the particular task in hand, or no tax advice. Under the Legal Services Regulation Authority, or Act rather, 2015, you're entitled by statute to limit your liability, and the best way to do that is to stipulate in your terms and conditions that it is limited to the level of your professional indemnity insurance. If your insurance, for example, is 1.5 million, you can contractually agree that that's the limit of your liability if anything goes wrong, even if we'll say the value of the transaction is 2 million. That's all covered under the provisions of the 2015 Act. Again, you have external referrals, but also be conscious of internal referrals. And just because somebody has been a good client with somebody else doesn't mean that they'll necessarily gel with you. or that you can manage them in the same way. You should treat them in the same way as you would treat a new client. When you're dealing with somebody, very important to make good old-fashioned attendance notes, record phone messages, texts, WhatsApp messages, emails, anything and everything, and make sure that it records any risk advice in particular. If you're having a conversation with a client and it is a crucial one, you should not only have the conversation, make a note for yourself, but you should document it back to the client. Many years ago there was one particular client whom I did not trust, and when we were having conversations, I used to dictate the note, the memorandum of attendance, in front of them and send it to them at the time. Notwithstanding this, they subsequently sought to deny exactly what had been mapped out and agreed. Equally, be conscious of your client. There's a deceased uncle of mine who was known for being a bit bullish and was not a man for detail. He was one of these red hat type Edward de Bono people who was great for the big picture but not for the small detail. He bought a pub and it was a long leasehold title, and I knew, having explained to him the difference between a long leasehold title and a freehold title, that he'd instantly forget. When the rent demand came in, he got on farting fire and said, "You never told me about this rent business," and I was able to refer to the fact that I had actually discussed it with him. I'd sent him the attendance note. I'd advised him in a letter in relation to the nature of the title, so it shut up that argument fairly quickly. Equally, I had a client, well-intentioned, not malicious in any way, but we'd have a consultation. He'd agree A, B and C. He'd go off and tell somebody that we'd agree D, E and F, and he'd probably go do G, H, I. So again, me being able to point to the correspondence that he had, but most of which he never, of course, actually opened and read, covered a record of exactly what we had done. My advice to him was that he needed to get a good PA, and he eventually did. Remember, if there's any ambiguity or a difference in recollection or memory between what the solicitor says happened on the one hand and the client says on the other, and there's no contemporaneous attendance notes available, the courts will lean against the professional on the basis that they ought to have kept the note. It's a different matter for the client keeping the note. A typed attendance note is obviously clearest, but you can also be recorded in other efficient ways such as email, handwritten notes, time recording, digital or audio recording or whatever. We're all getting used now to Zoom meetings. There's a facility to record Zoom meetings. Equally, you can make audio recordings, and once that's all agreed with the client and you're GDPR compliant, there isn't a great difficulty with it. Most particularly though, a note of instructions, advices, notes of risk should be taken down in writing and recorded in a reliable form, but very important, document it to the client. It's also important to note changes of instructions, changes in costs, and section 150 is important there. When something changes that would affect the amount of fees that the client is ultimately supposed to pay, you have to notify the client of all that. Changing circumstances of a case could do that as well. You might expect, for example, that there'll be an admission of liability and the case will be fought in quantum only, and suddenly you have a full defence being filed. Again, that's changing circumstances. You need to change your section 150s to accommodate that. Again, document all that to the client. In terms of claims, work with your insurers to report all circumstances that are capable of giving rise to a claim. Now, very often we'll get emails, letters from clients after we sent out the bill for the case you advised them never to take in the one place, and simply because they lost, they turn around and say they're not going to pay you, and what's more, they're going to sue you. Now, that's at the relatively low end of something likely to actually lead to a valid claim on your policy. But if you are in the habit of reporting things as low a risk as that, the assumption will be that you're not going to miss something that's fairly serious, and it'll paint a good profile with the insurers for future indemnity and renewal. So report regularly on claims or complaints. Show your broker that you have a good internal system for resolving complaints before they give rise to something that's likely to constitute a claim on your policy. So work with the insurance broker, take advice and guidance. They're experienced in risk, they know this area, and take advice from a colleague and get expert evidence or assistance if necessary. Operate a good internal complaints management procedure, review with your partners on a regular basis, including current or potential claims and incidents giving rise to a claim. Work out if a complaint comes in about one person in the firm, if you have more than one person in the firm, that is, to whom it is referred, how is it to be handled, etc. That should all be clear. You should have the policies in place, the procedures in place, so that you're not left scratching your head when it comes in. Again, avail of peer review. peer review of 2 or 3 files a month, randomly selected. It's a useful, non-contentious, low time consuming way. Now there's a difference between review and audit. Review is when you sit down and you say, what's happening with Susan Martin's file, or Niall Cawley's file, and you're told, oh, it's in the land registry, stamped, waiting to be registered, have the dealing number. If you audit the file and you find out that it's not even stamped, certainly hasn't been lodged, and there's no dealing number, then that's a problem. You need to do audits every now and again on files. Now, when it comes to the smaller practices, the question is, how do you actually go about doing that? You could team up with a colleague, another sole practitioner who's a friend, and get them to do the reviews and audits with you. Again, once you show that type of thing to your insurer, it portrays a good risk management profile, and it will help you when it comes to renewal. Use an electronic diary and case management system. Make use of an electronic diary system to record all key dates, statute of limitations, crucial dates for taking actions, whatever they might be. Making sure that things don't go on the long stretch. More and more there are cases being dismissed every month and every week for inordinate and inexcusable delay on the part of practitioners. The courts are much less tolerant of delay nowadays, so you need to be diarying things forward. It's very easy for a busy practitioner to lose sight of a file and suddenly a year has gone by. That shouldn't happen. You should have reminders in there to remind you to review your files regularly. Talk through any problems with colleagues, with your partners. If a problem does arise, get the objective view. Don't start wallowing in your own misery. The problem file won't sort itself out under the desk. Years ago we used to have a system in a larger practice in which I was a partner, and we had the principle of the yuck file. There's a file that is just yuck, and you could go to somebody and say, this is a yuck file, would you have a look at it? And they would, and they'd say, this is what you're getting your proverbials in a twist for. This is the way to solve it, do this, do that, and job sorted. Again, you could do that with a colleague. If you're a sole practitioner, we're all kind of afraid of appearing that we're human, but we are human. We all make mistakes. We're all not on top of our game all the time for whatever reason, so do something like that. The engagement procedures, make sure that what you're doing is taking on something that you're actually competent and capable of delivering. There's no point if you know nothing about planning, taking on a planning case. There's no point if you're talking about a huge company merger. Again, if you don't know anything about it, you should specify exactly what areas of the firm or the work the firm advises on and what areas it would never advise on. Recently, for example, Richard Grogan commented that his firm only does employment law and personal injuries. He does not do conveyancing, and he gave an undertaking to his insurers that he would not do conveyancing. Conveyancing is one of the high risk activities that you'll see from the presentation for the SLA that I'm going to circulate, and the insurers, as a consequence, had a better risk profile assessment of Richard Grogan's practice, and it resulted in a reduction in premium. Engagement procedures, again, limit your liability. You should include confirmation that limited liability is incorporated into your letters of engagement, your terms of business, so that you're limiting your liability as I've suggested. Check all your money laundering requirements, confirmation of compliance, designated money laundering report officer, location of documents relating to money laundering. Make sure you comply with section 150. You've gone through all the processes required. Make sure there's no conflict of interest between the clients that you already have, or between the firm and its clients, because again that can give rise to difficulties. Make sure that not only do you have engagement procedures, but you also have disengagement procedures. You should have a clear policy or a letter setting out the circumstances in which the firm would disengage from a client, and you should retain that discretion at all times. Years ago, I was asked by somebody, would I take on a client who was having difficulty with their previous solicitor, and the person who made that request was a good client of mine. I agreed to meet with the prospective client. I met with them. I should have been more suspicious or wary. I was a little bit suspicious and a little bit wary when they came. It was a company law issue, oppression of minority, and they came with the book Keen's Company Law and wanted a quote from it. Somewhat against my better judgment because of the pressure from the existing client, I agreed to take them on. The files eventually were transferred on a Friday, and on the Saturday morning I arrived down to find a letter on the step at home. from this client indicating their expectations in terms of the level of service, notwithstanding that I had written out before with my terms of business. They said they expected absolute priority to be given to them, that if they ever rang, I would take their calls without delay. I would give them complete and absolute priority on any given day in respect of anything they wanted. I immediately wrote and said, sorry, cannot match those. Come and take your files, take them to another solicitor. The serial client, people to be wary of, some perpetual litigant who demands absolute priority, like that client, from you, but might be unwilling to pay for that priority. It's one thing if you want to take somebody on because they're the Meta of the world or the Coca-Cola or whoever, and you get huge work from them. Make sure you get huge fees from them as well. Be wary the second time around the track. Is the person passing the baton for a good and valid reason? It could be that there's simply something, the case has gone in a different direction and the person who had it previously is no longer capable of handling it. It could be illness. I've had situations of colleagues who were ill asking me to take over files where they're perfectly capable in a legal sense, but in terms of their health they were unable to give it the attention it needed. Or are they handing you the unexploded stick of dynamite? Champertus Charlie, be very wary about funding litigation. The person who's, for their owners, is backing somebody in terms of taking litigation. That's Champertus is illegal still in this country. Beware of deferential donal. They procrastinate to the point where they can't make up their own mind and constantly defers to you and wants you to make the decision for them, or worse still is deferring to others, and that could be Champertus Charlie, or it could be a spouse or a family member. So you've got to be very careful, particularly in situations with older clients, for something like that. Dishonest Dan, enough said. If it's patently obvious that someone is dishonest or is in some way involved in criminal activity, which might be the source of your fees, again, very important. And remember, you have obligations to make disclosures in the event that you think there's an offence under money laundering regulations, etc. Dissembling Dermot, the story changes to suit whatever might be to their advantage. Now that might not be malicious, it could be an unthinking, unconscious action on their part, but you want to be very careful of suborning perjury in court. Again, a GMN, you have a feeling in your waters, something's not quite right. Generally, trust your gut. Again, you're under no obligation to take anybody on. If you don't have a good feeling, you don't have a good rapport with the client, you don't think you'd have a good working relationship with them, pass up the opportunity. Erratic Emily is fundamentally honest, but is unreliable to the point of making a poor, if not disastrous, witness in their case. Again, how are you going to resolve the problem? Rather than go to court, you may choose the mediation option. Again, happy to give a lecture on that at some point. Forgetful Fionn, easily swayed in recollection, or is derailed because of their own poor memory, or an impaired memory, or because of poor cognitive skills, or they just may be easily persuadable. Again, that can pose difficulties in case management. Greedy George will do anything in the pursuit of money or their own advantage, and doesn't see that might actually be a problem in terms of pursuing their case. And again, the courts are getting more interventionist in terms of the burdens they're placing on solicitors and the obligations they're paying on solicitors in relation to bringing forward cases where clients are not truthful or where they're wasting the time of the court, and orders for costs against solicitors are now being made. Last minute Larry, again, enough said. You do not want to be getting in circumstances where you're already committed to something for the next 2 days and something has to be filed within the next 2 days. You've warned that you're not going to be available, and they storm into the office when you're about to head out the door to something else and demand that you do the devil and all for them. Be clear in your warnings beforehand. Allow yourself plenty of time to get things done. Be conscious of the fact that you can get a chest infection and it can result in you having to take a week off work, as I'm doing this week. You're getting the privilege of a one-time guest appearance this week. So loose cannon player tends to fly off the handle, lose the head with people, whether it's staff in your own office, with council, court staff, or worse, the bench, and they're going to be their own worst enemy. Missing in action Mick can never contact them when they need to, or when contact is required to progress things or to take instructions. No pay Nelly, again, it's one thing if you agree to take on work knowing that you're doing it on a no phone no fee basis, or you're doing it on a pro bono basis, but you do not want to be taking on huge work that you're not going to get paid for. We can't afford to do that. No Sean Neve, somebody who literally just doesn't turn up for even their own case, if it comes to it. Oisin the optimist, a person who's unwilling to recognise any weaknesses in their own case and who constantly expects the best possible outcome. Again, on the mediation front, mediators will talk about the Watna and the Batna. The Watna is the worst alternative to a negotiated agreement, and the Batna is the best alternative to a negotiated agreement. The Oisins of this world are constantly looking at the optimism. Always look on the bright side of life, etc. Remember, that song comes from the life of Brian, where they're all nailed to the cross, they're all being crucified. They don't understand their own situation, and you can imagine Oisin up on the cross in that circumstance. Over the top, Teresa. You can fill in the blanks yourself there for that one. Principal Paddy, who wants to take the case because it's a matter of principle. That's fine as long as the principal is also going to pay their lawyers. Spineless Steve, again, somebody who is as weak as dishwater, and doesn't have the gumption for the fight, whatever it might be. Might have a perfectly good case, but is not prepared to actually stand up in court. Again, you've got to look at alternatives such as mediation. Two-Fix Tig, again, will tell you something, tell you you're wonderful, but then will go out and backbite you behind and set the ground for complaints against you. Vendetta D, Vincent, is somebody who's just out for revenge for some reason, whether that's a former business partner, a former personal partner, or spouse, and they'll rather burn the entire place down completely than let the other side win. The type of people who it's more important to them that they win rather than they achieve an outcome, or to put it another way, it's more important the other person doesn't win. A relative as a client can also be a source of great difficulty because they might expect free advices. They might fail to protect or to respect your professional judgment, as in, sure, wasn't I at your communion? I know you well. In other words, they have to use a solicitor, but they're using you because they think that they can get what they want. They have a negative view of your advice based on items that you don't know about, and they're not going to tell you. They may also have the potential to ruin family gatherings and create divisions of the family in the event of an unfavourable outcome in their favour. Equally, there's confidentiality issues involved. Years ago, my late mother, God rest her, said to me that she understood the concept of client confidentiality, but asked me, did it really extend to not telling her that her niece and goddaughter had gone over the handlebars of her bike and broken both her wrists? I was handling the claim for my cousin, but I didn't mention anything. So, client complaints. These are some stats taken from the LSRA reports in recent years. This is for the October 2019 to March 2020 period. And you'll see the areas in which complaints about services by solicitors come up. Litigation, probate, conveyancing, family, topping the list. March 2020 to September 2020, again, the old faithfuls, litigation, probate, conveyancing and family. September 2020 to March 2021, litigation, conveyancing, probate, family, crime coming in, employment. 2021 to September 21, litigation, conveyancing, probate, family, crime again. And then September 21 to March 2022, litigation, conveyancing, probate, family, crime. So you can see they're the high risk areas in terms of potential complaints of clients and consequently potential claims that may result in a claim for indemnity from your insurer. Provincial breakdown, you have it there, Munster and Leinster running roughly side by side. Now, part of the difficulty is getting data, reliable data from insurance companies. Not all the insurance companies will actually share the data, but this is based on the available data and information. And again, this is a breakdown on claims by county, but that all comes from one particular insurer. Again, the nature of claims generally, PI statute barred, residential property clients, commercial property clients, agricultural property clients, litigation in terms of debt, property breach of undertaking, as in unfulfilled registration, or perfection of title, employment and probate. So, does your office have a system for recording, monitoring and reviewing the key dates, including a procedure for absenteeism? If somebody is absent, who takes over their workload, who checks their work, who checks their diary? You have to have a system in place to allow for all of that. Checking on progress and activity, prioritising work and dealing with problem cases. If you have an electronic case management system, it's much easier to do because you don't have to read back through all the file. Again, back to the competency issue, check any disputes or difficulties arising particularly from undertakings given by your firm or accepted by your firm. Deal with the complaints regularly. Check in with staff on a regular basis to see if there's anything that is worrying them. If an employee has left, then carry out a review of their files. Even if an employee has not left, carry out a review of their files. And as I said already, put in place a system for audits. Check the files being handled by the appropriate person. Try and match the type of work to the appropriate person. A number of years ago, I was asked to go in to try and sort out difficulties in a firm where they had moved from a competency-based allocation of work to every man for themselves. So you suddenly had people who hadn't done a conveyance in 20 years trying to do conveyancing, etc. And it was leading to all sorts of problems. Eventually the practice split apart. So check your register of undertaking system, your critical date systems, your cyber security. Check your data is properly secured. Again, as you'll see from the PowerPoint presentation in relation to PII, the basic cover now for solicitors for a number of years, thanks to the great work of Richard Hammond and Barry McCarthy as previous chairs of the PII committee, and Sir Hayes in the Law Society. Cyber cover to protect client funds is now part of your basic professional indemnity insurance package. It doesn't cover your own funds, but it does cover client funds. And if you try to get that in the market now, it would be financially impossible to do it. Murphy's Law, if anything can go wrong, it will. And at the worst possible moment, my commentary on that, Murphy must have been a bloody optimist. So again, prepare to plan and plan to prepare. And a book you'll hope you'll never have to read. I've already mentioned that I'm going to give you a freebie of the first 2 chapters of this book, which relates to the creation, the maintenance and the termination of the contract retainer of the solicitor. The remaining chapters I'm not going to give you, and hopefully you'll never have to read it. So, any questions, ladies and gentlemen? Thank you very much.